Welcome to the Software Process and Measurement Cast number 653. I'm Tom Cagley, your host. Intellectual property protection impacts almost everyone, whether they are aware of it or not. Trademarks, copyrights, patents, and trade secrets are part of a wide-ranging discussions of IP protection in the software environment. Rick provides great insight into a rapidly evolving field. Rick Martin is the owner and founder of Martin IP Law Group, which is based in Evansville, Indiana, but serves clients throughout the United States and, as he points out in the interview, the world. He is a graduate of the Purdue School of Industrial Engineering and the Catholic University of America Columbus School of Law. Prior to beginning his career as an intellectual property attorney, Rick worked as a patent examiner at the U.S. Patent Office. Rick has obtained hundreds of patents for inventors in a variety of fields, including timing systems, mining safety devices, broadband antennas, RFID, electronics, ranging, oil and gas, semiconductors, and other mechanical and electro-mechanical devices and software. Over 25 years, he's been helping entrepreneurs and businesses protect their ideas, inventions, identities through patents, trademarks, copyrights, trade secrets, and related contracts, licenses, and agreements. Are you ready to examine intellectual property rights? It's time for the interview. Rick Martin, welcome to the Software Process and Measurement Cast.
Thank you, Tom. Glad to be here.
I am looking forward to this. This is an interesting topic, and I think it's a very timely topic. Let's talk about intellectual property, and well, let's start at the beginning. People probably have all sorts of ideas as to what that means. In terms of software, what does intellectual property mean?
Well, intellectual property, and it's kind of a foundational issue with regard to software and any technology in general, but intellectual property is really just sort of they're intangible rights that protect ideas, they protect inventions, they protect various aspects of the software from the creator's standpoint. And essentially, there are kind of the four pillars of intellectual property, if you will. There are patents, there are trademarks, copyrights, and trade secrets are typically the four main areas where legal protection applies within the scope of intellectual property.
Are all four of those discrete, or are they overlapped? And could you have a trademark and a patent and a copyright and consider it a trade secret?
I suppose there could be a software package where you have all four. Yes, trademarks, I'll start with them because they're a little bit different than the others. The trademarks don't really protect the technology itself. It protects the branding that goes along with the product, the software product that you're marketing or selling. So it's trademarks are the symbols, the names, the logos that distinguish the product in the marketplace and that are used to basically identify who is the source of this software product. So it's different. It can apply really universally to all software products, and is probably important for anything that's, whether it's software or other products, it's important for anything that's really out there in the marketplace to kind of protect your brand, if you will. Trade secrets, copyrights, and patents deal more with the technology side of things. With regard to software, copyrights kind of protect not necessarily the idea of the software or what it implements, but typically when you're dealing with copyrights and software, it's the code that's protected from a software perspective. Copyrights traditionally apply to things like music, art, books, things of that nature. They have applied it now to software and like I said, particularly in the coding of the software. Trade secrets are basically those things. The best example of a trade secret is the Coca-Cola formula. And trade secrets have no expiration date as long as you can keep them secret. So the Coca-Cola formula, they've managed to kind of keep that under wraps for well over 100 years now. that no one, and again, typically that's done through confidentiality agreements with your employees, agreements with anybody that gets their hands on that secret sauce, so to speak, to say, okay, if we give you this information, you're going to agree not to use it in certain ways. You're not going to disclose it to anyone else. And so trade secrets, there's not really a process where you apply for and are granted rights through a government agency like copyrights, trademarks, and patents, but it's more done transactionally through contracts and through agreements and through the company internally keeping things secret. It typically applies to things that aren't easily reverse engineered. So again, the Coca-Cola formula is a good example. Really difficult for somebody to take a can of Coca-Cola and figure out exactly what is in it and how much. So to the extent that there are elements of software that kind of line up with that, then they can be protected by trade secrets.
For those of us who are probably addicted to Coke and Diet Pepsi, we probably don't really want to know what's in those cans anyway. Yeah,
that's probably true. Probably true. Patents are another animal there. Patents protect the inventions. They're granted for a limited period of time. A 20-year monopoly is basically granted on the patents from the date it's filed. If a patent is granted, that you get the exclusive right to make, use, and sell that invention. And again, it typically, when you're dealing with software, if you want to get in the weeds on this, we can. There's a case called Alice from 2014 that really kind of redefined software protection for patents. But it kind of is going to protect more the functional aspects of the software and how it works rather than the code itself, which is copyright.
Alice, I mean, that went all the way to the Supreme Court, didn't it?
Yes, it did. And again, looking at copyright, we had one just last month go all the way to the Supreme Court, and that was Oracle. They've really kind of redefined how copyright applies to software too. So those are kind of really in the software world. Alice and Oracle are probably two very important cases that define, what intellectual property protections apply and how are they going to be applied and interpreted. We have the benefit with Alice, that was from 2014, of getting a feel as to how the subsequent courts and the patent office are treating that and interpreting it, although it's still an ever-moving target. Oracle, like I said, that just came out last month, so a lot of speculation on what that means and how that's going to shake out. But yeah, two decisions from the highest authority in the land, so it's nice to see that they're actually giving some attention to patents in the last 10 or 20 years.
How long has software and the derivatives out of software been being litigated in terms of copyrights, patents, those sorts of things? I can always see trade secrets, right? You can probably make anything a trade secret until somebody else figures it out. But how long have we been at this in terms of trying to take, what's probably some of it a fairly ancient legal code and applying it to stuff that's maybe even a little different, maybe a lot different?
It's a good question, probably a very tough question to answer because I can't put a specific date on it, but I would suspect, just like anything else, as soon as the rights were recognized and granted, there's probably been litigation since the first patent or copyright issued on a piece of software because it's always going to be something that's in dispute. I mean, these are pretty valuable assets. You're looking, this latest fight was between Google and Oracle. So you've got billion-dollar companies squaring off over rights to their software. So really, since software has become big business, there's been litigation, both on the patent side and the copyright side.
Mm-hmm. What's it like to actually be someone who's in this market, and how did you get to the point of actually doing this kind of intellectual property work and talking software?
And it's just kind of one of those things that evolves as to how you end up where you are. Going all the way back, I got an undergraduate degree in engineering from Purdue University, and really wasn't sure that I wanted to practice engineering. So I started looking at law school. Wasn't necessarily sure I even wanted to go into intellectual property at that time either, but I happened to see that the patent office was interviewing for jobs on campus. So that kind of interested me. Looked into it, went to the interview, got offered a job. They had a program at the time where if you worked as a patent examiner during the day, went to one of the night programs for law school, they would help pay for a significant chunk of your tuition. So it seemed like a good fit to me to, help pay what was today probably doesn't seem like a lot of money. I'm sure it's a lot more expensive to go to law school, but back then it was still pretty pricey as well. And it was a good way to kind of help fund that goal of mine. And again, the more I got into it, the more I worked at the patent office, I kind of started to like that and kind of developed an interest in it. And then, that kind of branched out to the other areas of intellectual property and started practicing in that area. And, just clients come along and, you just start doing certain aspects of the practice. And there's certain things that interest me more than others. And the software has really been one. And again, like I said, it wasn't so much of an issue from a patent side until 2014. Most of my practices is, acquiring the rights for clients. Every now and then I'll do some litigation work, but it's applying for and securing patent rights, copyrights on their inventions and on their designs and such. So everything chugged along pretty nicely, at least on the patent side, until Alice came along. And then it just really changed the whole landscape and really redefined how we had to apply for patents for software.
How is software patentable?
And again, that's a good question, and one that I think we've been struggling with ever since Alice, because the Alice decision really kind of suggested that it wasn't. It wasn't. And I think a lot of people at the time that Alice came out, I think the thinking behind Alice was, well, these software patents are really just using a computer as a tool to accomplish a task that could be done manually. They're abstract ideas, and there's really no inventive concept to it. And a lot of people felt that was probably, the Alice decision was the end of patents for software. But there are some, novel aspects, some unique aspects, some things that software does, that are novel, are patentable, and are different and are distinct. So again, it's a fine line, and Alice kind of made it. I would like to say it made the line even fuzzier than it was before in some sense, but in some sense it clarified things as well. So it gave us a better set of rules. Again, it's a lengthy set of rules, and we've got a limited amount of time, so I'm not going to get into that. But it blurred the line, but it set out some pretty specific guidance and rules that the patent office has now adopted in line with Alice as to what is and what is not patentable in the software realm.
Why is protection for intellectual property important? Why is it important for, Sandeep programmer, right? I'm down in the trenches. I'm working for a big corporation versus a friend of mine, Tony Timble, who's a real person who just created a new company with a piece of software. Is it important for both of those? Is it more important for one than the other? Why?
I would say it's important for both, probably for the individual developer more so than the worker at for a big company, although it's very important for that big company that they work for, and oftentimes the company will have incentives for employees that develop patentable inventions or develop software that's subject to copyright protection. I know a lot of larger companies do offer incentive bonus, and that typically if you work for a company and you develop, a piece of software as a part of your employment for that company, then the company owns it, you don't own it. In the copyright world, that's essentially what's called a work for hire. And so, I guess it's a little less important to them because they don't necessarily own something. But again, they're being paid to develop that and paid to do that. That's their job. So, if they want to do a good job, I suppose it's important for that. Again, from a patent perspective, typically you're going to have an assignment of rights, and this programmer or inventor or whatever that works for the company is usually going to have an employment agreement that says, the company owns, anything I develop. So it's important to the growth and betterment of the company. And again, the individual that owns the company, it's important to them in the same way it is to the big company, in that these are assets. These are things that the company, whether big or small, is putting a significant amount of time, resources, and money into developing to get a competitive advantage over, others in the industry. And, the dating all the way back to the founding of the United States, they recognized patents to grant, a limited monopoly to encourage. And again, the patent system accomplishes two things. One, it gives you that 20-year limited monopoly. So there's an encouragement to develop something, to invent, to spur innovation, and give you that 20 years to where you've got that exclusivity. So, it gives businesses an incentive to do that. But the other side of the patent is, in order to be granted a patent, you have to fully disclose what your invention is in the patent process, which is, again, different than trade secrets. So in fully disclosing all of your invention to the public, yes, you get the 20-year monopoly on it, but everything you've done is out there for the next guy to build on and the next guy to build on after that. So it kind of spurs innovation and promotes growth in that respect. So the patent system is really interesting in that it does both, and it's functioned well like that for years.
I'd like to come at this just a little bit out of phase, and this is something that, as someone's worked in many companies and seen a lot of different applications being pieced together, I don't know that everyone thinks about. So look, building a piece of software, and in that process, hypothetically, somebody decides to copy something from the internet, and not a bad thing, right? But is borrowing a piece of code from somewhere else without having the rights to it. Doesn't that put an organization at risk? And how would they go about getting the rights to something like that?
I would say yes, it does put them at risk for, and again, more so probably for copyright infringement than patent infringement. I mean, the copyright protection attaches upon creation of the software. So that's almost automatic that there's copyright protection. So when you're taking a piece of code and copying it verbatim and putting it into another piece of software that you're creating, technically, by definition, assuming that there's software protection to that, which the Supreme Court didn't decide in the Oracle case, they punted on that one. But assuming that there's software protection in those lines of code, then by definition, that's infringement. So yes, they do need to be concerned about that. However, I'll circle back and talk about the Oracle case here in a moment as to why that might not be a huge concern. But yeah, it's concerning.
What can they do to not have that risk?
Well, what they can do to, I guess, minimize that risk is to contact the owner of the software that they're copying prior to doing that, to see if they would grant them a license. And that happens all the time. That, and again, it's an arm's length negotiation. You approach them and say, hey, we'd like to use this portion of your code to develop this piece of software. And if they say yes, then, you negotiate back and forth and agree to terms on what you're going to pay them. And typically it's a percentage or a royalty on sales of future software that you sell using their code. And that's oftentimes done in the industry. And in fact, in the Oracle case, and that leads well into that, they requested a license. Google requested a license from Oracle to use that, and they couldn't come to terms. And Google, Google's a big enough company. They were armed with lawyers, and assume that their lawyers advise them, you don't really need a license on this anyway. It's, well, in software terms, what's considered fair use. And that's ultimately what the Supreme Court decided in that case. After years and years of them battling over it, the Supreme Court decided that Google's use of those lines of code from Oracle were considered fair use of their copyrighted code, and therefore didn't constitute infringement.
I mean, that was basically boils down to the Unix kernel, right?
Yeah, it does. And the interesting thing though is, and again, people are trying to read the Oracle case and trying to kind of decipher what does this mean for the software industry? What does it mean going forward? And again, it's uncertain because the case has just recently come out. But the question now is any use of software fair use? As long as I think there's a certain distinction in that case. They didn't copy the entire program, just certain lines of the code that they needed to do what they needed to do in that case. But it sort of begs the question, is the Supreme Court or our courts going to interpret virtually any use of someone else's software as fair use? And again, we won't know till the next case and the next case come down, and there will be a line somewhere, because like I said, if you copy all of it and you're competing against them directly, that's going to be clearly found to be infringement. But where you're taking a piece of code, you're using it in something that doesn't compete with them, you're using it in a very limited manner like they did in the Oracle case. And I think there was an even argument in there that Oracle actually benefited from that use. It's probably going to fall on the side of fair use and not infringement.
And that's why the law evolves. Once upon a time, you could probably go to a library and find all sorts of books with laws in them. And now you just go online and get the same thing. But, that's why they publish them every year. And that's why there are big publishing firms that, publish virtual and non-virtual legal books all the time, because it evolves and different decisions push that forward. Rick, this has been absolutely marvelous. If you woke up tomorrow morning and somebody handed you a cup of coffee and a magic wand and gave you 2 wishes that you could use to change how intellectual property is interpreted, used, litigated, controlled, what would those 2 things be and why?
Well, at least with regard to software, one, I'll say, I hope I wake up in the morning. You said if, so.
Let's assume that you have.
I hope that I wake up tomorrow morning, and if I do, I definitely need coffee because I have that every day to get my day started.
Understood.
But that being said, 2 things with regard to IP. Again, maybe, and I'll even try and focus it more on software. A little more clarity on where the line is here would be nice. I've got several applications that are working their way through the patent office that before Alice, I really didn't have any difficulty getting through. And I've got some examiners. There's not a lot of consistency in application there sometimes at the patent office. I'll have one examiner that will agree and allow something, and in almost an identical situation or case, fighting it, tooth and nail to try and get something through. So a little more consistency, I think, not only within the patent office examining corps, but just from the top down on how this is to work would probably be the first thing that I would like to see. Second thing, gosh, I'm trying to think what that might be. I guess, and this is maybe a topical issue too, is I would like to see a little more governmental support for the enforcement of intellectual property rights. I noticed just recently that the Biden administration is making a push with, I think it's the World Intellectual Property Organization, to essentially waive patent rights for COVID-19 vaccines, which in and of itself seems like a noble thing to do and a good thing to do to kind of help everybody else out to kind of get their vaccine programs up and running. But most of the articles I've read on it, and based on what I know about the process and the market, it's not going to help them get shots in arms any quicker by waiving the patent rights on those vaccines, because it's still a fairly intricate process to get a factory up and running and to produce the vaccine. And just granting the patent rights doesn't make that happen, and two, certainly doesn't make that happen overnight or anytime in the very near future. Many other things they could do that would be more effective than that. The concern I have with the government waiving or wanting to waive patent rights in that context is what's next. And so back to my original point, I would like to see a little more support for enforcing patent rights from the federal government, and I think I see them going the other way right now, which is a little concerning.
Rick, how would people continue the conversation? How would they reach out? How would they find you?
Well, like I said, we're here in Evansville, Indiana, which is crossroads of America. However, I have clients all over the United States and some international. That's been one of the great things about one of the benefits of the pandemic is Zoom and all these other platforms have come on, which makes it easier for me to work with clients wherever they are. The intellectual property law is all federally based. So, the law essentially that we're working with is the same in Indiana, Florida, California, New York. The laws are the same, so we can help people with their intellectual property matters regardless of where they're located. Our website, www.ipsolutionslaw.com, is probably the best place to find us. And there's just a little background, a little information there. My email is just Rick, R-I-C-K, at ipsolutionslaw.com. Those are probably the best ways to reach out to us and see if there's something that we can help you with.
Super. At this point, I open up the platform for you to promote anything else that you'd like. Podcast has been on for 15 years, show 0. The one that opened it still gets downloads, so might be out here for a while. Selling your car on eBay, probably not the best use. But the platform's yours, 2 to 3 minutes, all yours, Rick.
Okay. One of the other, a couple things we do differently here than I think a lot of other firms do is, I've been doing this for 25, 30 years now. So I usually have a pretty good idea how much time I'm going to have involved in a project. So unlike traditional law firms that bill you by the hour for the work that they do, we've adopted a project-based approach where it's a flat fee for a certain project, regardless of how long it takes us to get it done. So I find clients like that better because there's more certainty in it, and it's an incentive for us to be efficient in getting the work done rather than inefficient and making more money. So that's one thing we do differently here. We've also recently started another program. I call it fractional counsel. I'm still wrestling with a good name for it. I need to come up with a good catchy name and trademark it, but I haven't done that yet. I'm still looking for a name, but basically it's fractional counsel is what it's referred to in other places. And it's a scenario by which we essentially are acting as in-house counsel for typically small and medium-sized companies that have IP, issues, whether it be software or other, hardware-based applications. But they've got branding issues. If they've got products they're selling, they obviously have branding issues. If they're developing products, R&D department, whether it be software or otherwise, there's potential patent protection, potential copyright protection. A lot of companies, go down that road and really either only go consult with an attorney after they have a problem, or maybe don't consult with an attorney at all, or consult with an attorney, an IP attorney, when they think they need protection for something. This program we've developed is, like I said, it's essentially a part-time in-house counsel that we're acting as. So we're interacting with the client on a regular basis, basically planning strategy going forward. We'll touch base with them. What are you working on? What are you developing? And before, even before it triggers in their mind that they need IP protection, we're already there. We're already thinking ahead. We're already planning. We're already identifying what needs to be protected and getting it protected before it's too late in some instances. So that's a program we've started. We've got a handful of clients on that now. Seems to be working well again, and that we do that also on a flat monthly fee, and that's on a client by client basis. We'll sit down, figure out what your needs are, and develop a program that's specific to that company's needs and that works best for them, and at a price point that works for them as well.
Cool. Proactive rather than reactive.
Yes, exactly.
Super. Rick, this has been absolutely marvelous. I've got a page and a half of notes, and that's my goal, right? Learn something new every day. So I think you've educated the Software Process and Measurement Cast listeners, and I hope they reach out and leverage some of your services.
All right. Well, excellent. Well, thank you, Tom. I've enjoyed being on the show, and thanks again.
In Reread Saturday News, this is the last chapter of content, Chapter 15 in Fixing Your Scrum, Practical Solutions to Common Scrum Problems by Ryan Ripley and Todd Miller. In this one, obviously, we're covering retrospectives. The retrospective, I think, is the most important part of Scrum. Helping it to work well is important. Next week, we conclude our reread with a few closing remarks. Make sure I have your input on the reread. Go to the show notes and vote. If you don't want to go to a poll, shoot me an email at tcagley@tomcagley.com. If you've not bought your copy of Fixing Your Scrum, what are you waiting for? Link in the show notes. In the next Software Process and Measurement Cast, we will feature a longer essay titled Work Entry and Introduction. This essay brings together a number of concepts to focus on what work entry is and why it is the single most important part of determining whether a team is dependable, predictable, and whether or not they're ever going to be agile. We also have a visit from John M. Quigley and his Alpha and Omega of product development. If process improvement is a never-ending journey, why do so many people ask, are we there yet? If process improvement is a never-ending journey, why do so many people ask, are we there yet?